Most cross-border estates do not fail because of tax. They fail because of conflict. Inheritance disputes in Vietnam involving overseas family members are increasingly common. And once conflict begins, procedural complexity multiplies. Why overseas family members change the dynamics? When heirs reside in different countries, legal systems overlap. Time zones differ, documentation standards differ, expectations differ. Vietnamese courts must operate within domestic law regardless of foreign assumptions. The most common trigger: disputed validity of a will. Many inheritance disputes begin with a challenge to the validity of a will. Allegations often involve lack of testamentary capacity, improper witnessing, or undue influence. If the will was drafted abroad, legalization and translation become additional pressure points. Forced heirship claims. Vietnamese inheritance law protects certain compulsory heirs under the Civil Code. These include minor children, adult children without working capacity, the surviving spouse, and parents of the deceased. Where applicable, courts may adjust testamentary distributions to preserve statutory minimum shares. Overseas heirs are often surprised when Vietnamese mandatory rules alter the outcome. Conflict of law questions. One party may argue that foreign law should apply. Another insists on Vietnamese inheritance law. For removable property in Vietnam, domestic law usually prevails. This legal reality shapes the outcome early. Documentation gaps across borders. Disputes often escalate because required documents are incomplete. Foreign birth certificates, marriage certificates, or probate orders must be legalized and translated. Delays create suspicion among family members. When heirs cannot travel to Vietnam, overseas heirs frequently rely on powers of attorney. Improperly legalized authorization are rejected. Procedural defects become strategic leverage in contested cases. Real estate is the most litigated asset. Land use rights and residential property in Vietnam are frequently central to inheritance disputes. Title transfer cannot occur while litigation is pending. As a result, property may remain restricted for extended periods during judicial proceedings. Business interests add another layer. If the deceased owns shares in a Vietnamese company, inheritance disputes may affect corporate control. Voting rights, dividend rights, and management decisions can become entangled in family conflict. Commercial consequences often extend beyond the estate itself. Second marriages and blended families. Inheritance disputes frequently arise in second marriages. Children from previous relationships assert statutory rights. The surviving spouse may face competing claims from overseas heirs. Challenges to foreign wills. Foreign wills are often challenged on procedural grounds. Was it properly executed? Was the testator competent? Was the document accurately translated? Each technical issue becomes material in litigation. Mediation before court. Vietnamese courts encourage mediation before formal trial. In cross-border disputes, mediation can preserve assets and relationships. However, emotional distance and jurisdictional complexity often limit compromise. Poor procedure in Vietnam. If mediation fails, the dispute proceeds to trial. The court evaluates statutory inheritance rights, will validity, and asset classification. Foreign judgments are not automatically decisive. Timeline and cost implications. Inheritance litigation involving overseas family members typically extends well beyond uncontested inheritance procedures. International document coordination, expert evidence, and jurisdictional challenges may be required. Cost and duration increase proportionally with complexity. Enforcement challenges. Even after judgment is issued, enforcement may involve additional cross-border procedures where heirs or assets are located abroad. Recognition of Vietnamese court decisions in foreign jurisdictions is not automatic. Enforcement strategy must be assessed jurisdiction by jurisdiction. The role of transparency before death. Disputes are often fueled by surprise. When family members are unaware of estate structure, suspicion escalates. Transparent planning while alive reduces post-death litigation risk. Strategic document management. Maintaining properly legalized and updated documents is not administrative detail. It is litigation prevention. Cross-border estates require structured record keeping. A practical takeaway for overseas families. If your family spans multiple jurisdictions and assets include property in Vietnam, anticipate jurisdictional friction. Do not assume informal agreement will prevail over statutory rules. Legal alignment across borders is essential. Inheritance disputes in Vietnam involving overseas family members are legally complex and emotionally draining. They combine family law, property law, and conflict of law principles. Preventive structuring is significantly less costly than cross-border litigation. For multinational families, proactive planning is not optional. It is protective. If your family spans multiple jurisdictions and includes assets in Vietnam, inheritance disputes should be anticipated, not improvised. Vietnamese courts apply domestic inheritance and property law regardless of foreign expectations. Where overseas heirs are involved, documentation, recognition procedures, and compulsory heirship protections must be assessed early. To design preventive structures or manage cross-border inheritance litigation strategically, contact LTS Law at lts.com.vn. In multinational estates, conflict is rarely accidental. It emerges where structure was absent.